The first matter to come before the court this morning is State of Ohio versus Theodore McCrae. Both sides would ordinarily have 15 minutes to argue. The appellant, it is now 9:40. This case was set for 9:30. The appellant has yet to appear. The state wants to go ahead and proceed if the appellant arrives. If there's 5 minutes left for rebuttal, for time for the appellant to argue, we'll allow that. Thank you.
Thank you.
We've read the briefs. We're ready to proceed when you are.
Thank you, Your Honor. May it please the court, Heaven D. Martino on behalf of the appellee of the state of Ohio, we are asking that this court affirm the trial court's decision allowing expert testimony regarding firearms tool mark analysis presented by forensic scientist Mr. Gardner. This state essentially appeared today to answer any questions that the court might have and to rebut any arguments that Mr. Madison might have presented. I would just point out that the arguments in the appellant's brief are nearly verbatim to an article published in 2002 in the National Association of Criminal Defense Lawyers magazine entitled Daubert Challenges to Forensic Evidence Ballistics Next on the Firing Line. Again, that was in 2002, and it was an article talking about a federal case, U.S. versus Prillo, where the court allowed the testimony on the tool marks analysis, however, the jury acquitted. And the article was basically saying, let's hope that there's a shift in the way the courts view this tool mark analysis. But ultimately, there has been, 13 years later, no court that has not allowed the testimony. If you look, even the headings are verbatim to what was in that article. So there is no support for that argument. There's just this article that was out there. That Prillo case was involving a Raven, which is a cheaply made gun. This case involved a Glock, which has more specific tool mark analysis. So the state would argue that the trial court did not abuse its discretion in allowing the testimony. It's consistent with the case law, and the evidence presented was helpful to the jury and was reliable. The forensic scientist testified that when he fires the gun into a water tank, the bullet is still pristine. It allows for a comparison underneath a microscope, and he was able to establish that all 8 shell casings were fired by the Glock that was submitted into evidence. If there are no questions from the bench, I would ask the court to affirm.
Go ahead.
I have a question. In reading the briefs, it was not clear whether the court conducted a formal Daubert hearing or whether the testimony of the state's expert was quoted from the transcript of the trial.
There was no Daubert hearing because the report was given to the defense on March 7th. On March 19th, there was an in-chambers discussion where the defense did not raise any issue as far as the tool mark evidence. The defense insisted that the trial start on March 20th. It wasn't until the 3rd day of trial, immediately before the scientist, Mr. Gardner, testified, that the defense presented this motion in limine. And the court noted that if you had raised this issue on the 19th or after you spoke to your expert on the 21st, or maybe even raised this issue on the 1st day of trial, I would have considered it. But here you are on the 3rd day of trial, you're raising this issue. There's no reason to have a Daubert hearing, so the court did not allow it. So the scientist did testify, and any testimony that's quoted is from the trial, not from any Daubert hearing.
And did defense counsel, just to follow up on that, excuse me, did defense counsel cross-examine the defense expert with, well, I would say the information that was set forth in the brief that you say came from the article?
They cross-examined the witness, but they did not go into the detail that's in that article. So there was a cross-examination. Also, the defense did not object at any time during Mr. Gardner's testimony. There was just that motion to eliminate filed immediately before he testified, and that was it. It wasn't raised again. There was no objection.
Okay. Well, I raised the question because I noted in the appellant's brief there were no references, no citations to the record.
Great.
Thank you.
Are there any other questions? Thank you. I rest on my brief.
Thank you for your presentation today. I'll take the matter under advisement and issue a written decision which will be sent to both sides.
Thank you.
Adjourned until 10 o'clock.